Hello everybody, welcome. It's a beautiful day today here in Great Neck. It's a bit windy, but I wanted to share some great information with you, which is today's topic of how do you take control of a doctor's deposition? So come join me on this walk around the neighborhood as I share with you the answer to that question. Alright, so now here's the scenario. Let's say you decided to bring a lawsuit against your doctor claiming that he was careless, causing you significant harm and injury. And now, what does your doctor do? Your doctor denies all of those allegations. Okay, so what does that mean? It means now you're going to go through the lawsuit process. And that means that we will have an opportunity to question the doctor during the course of your lawsuit. The doctor's attorney will have an opportunity to question you, the person bringing the lawsuit, and we call that a deposition. It's really pretrial testimony. It's really a question and answer session that's given under oath, and it takes place in the attorney's office, in his conference room. And you should know something. There's no judge present. There's no jury present. And you might be wondering, how is that possible? Well, I'm going to share something with you. You should know something very important. That even though there's no judge present, even though there's no jury present, the answers that the doctor gives, or in your case, if you're giving the deposition, the answers that you give carry the same exact weight as if you or the doctor are testifying at the time of trial. So now, how do we know what the witness has said for later on when the case ultimately gets to trial? I'll tell you how we know. We know it because we have a court stenographer in the room. So in the conference room is going to be me as the attorney questioning the doctor. The doctor will be there, the doctor's attorney will be there, and now we have a court stenographer who is there to record all of my questions and all of the answers that the doctor gives. And why is that important? It's important because those answers are recorded and become the sworn testimony that we can now use at the time of trial. All right, so now let's get back to the title I raised in the topic of this video, today's video, which is how do you take control of a doctor's deposition? I'll tell you how. By asking the key questions involved in the entire case right away. You know, most attorneys are trained to go ahead and ask questions such as, Doctor, tell me about your credentials. Where did you go to medical school? Where did you go to undergrad? Where did you do your residency training? Now, those questions are important, but I will tell you something else. They're not as important because they've got nothing to do with the key issues in this case. You see, the doctor is prepared for those questions. Those are simple questions that he knows off the top of his head. I don't care about that. I'll get to that later on at the very end of the case, at the very end of my questioning. Why? Because I already know the doctor's credentials. And you know what? It's no effort on his part to tell me where he went to school and the training that he did and whether he's licensed to practice medicine in the state of New York. So I'm going to save that information. I'm going to save those questions for much later. That is not how you go ahead and control the deposition. One of the best ways I have found during the course of my career to actually take control of a doctor's deposition is by asking the key questions at the very beginning. So I'll give you a great example. Let's say this is a case involving a surgery that was done improperly. And now our claim is that the doctor operated on the wrong side of the patient's brain, causing significant harm and injury. All right, so I want you to assume those facts to be true. We call that a hypothetical question. All right, but assume that those are the facts. Here's the scenario. So now, at the time of deposition, instead of me asking the doctor about questions about his credentials, what am I asking? This is my very first question. Good morning, doctor. Can you tell me why you operated on the wrong side of the patient's brain? Oh my God, objection, the defense attorney yells. And now he'll give me all sorts of objections to claim that I can't ask that as my first question. And you know what? Then I'll have a brief, pleasant conversation with the attorney saying, listen, can you show me where in the rules or the laws that we have that says I can't ask the most important question in the case as my very first question? To which he'll stumble and give me lots of excuses. And the bottom line is, he may say something like, listen, you haven't laid a foundation. Now what does that mean? It means I haven't established what we call a setup. I haven't set up the question to show that this guy, this doctor, did in fact operate on this patient, that he had a doctor-patient relationship. So I'll say, fine. All right, doctor, isn't it true that you were treating this particular patient on January 1st? Yes. And isn't it true that the patient had agreed to have this surgery that you recommended? Yes. And you went ahead and performed this surgery on January 1st. Isn't that true? Yes. And isn't it also true, doctor, that you operated on the wrong side of the brain? Objection, objection. And now again, we get into other objections. But the point is, what have I done? I've taken control of this deposition. And how did I do it? By going right to the heart of the matter, getting right to the issues in this case, and then I can ask lots of stuff afterwards about his treatment records and about what the standard of care is in this scenario. Doctor, isn't it true that before you ever performed surgery on this patient, you had a conversation with the patient in your office? Yes, it is. And during that conversation, you came to the conclusion that this patient needed to have surgery on their brain, correct? Yes. And it was your intention to perform surgery on the right side of the patient's brain. Isn't that true, doctor? Yes, it was. And in fact, the patient signed consent to have surgery on the right side of his brain. Isn't that true? Yes. And there was never an intention to perform surgery on the left side, correct? Correct. All right, doctor, let's look at the operative report. Isn't it true that according to this operative report, you operated on the left side of the brain? Well, yes. And now the doctor will give me some answer that addresses that. Doctor, isn't it true that you operated on the wrong side of the brain? So again, what have I done here? I've simply taken control of this deposition by asking the doctor questions that he's certainly not expecting at the very beginning. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I recognize and I understand you're likely watching this video because you have questions or concerns about your own matter. Either that or this just showed up on your feed and you got interested and you started to press play and watch. Well, either way, I hope you found this interesting. I hope you found it enjoyable. And as always, if you have questions about your matter that happened here in New York and you have not yet started a lawsuit and are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. And we can have a chat while I walk around the neighborhood shooting more videos. No, seriously, pick up the phone and call me. I'm happy to chat with you if you've not yet started a lawsuit and your matter happened here in New York. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.